hubcitysoapery.com. Hub City Soapery. Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery. Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients, at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview, or shop online at hubcitysoapery.com. Hub City Soapery.
We have arraignments. Do you want to start the afternoon docket after arraignments at 2 versus 2:30, or you want to keep them at 2:30?
I mean, generally, we end up with it running all the way until 2:30, so.
I would say that it would be great to bump it up and have an earlier time until you have a big arraignment docket, in which case then we're going to be swamped.
And so that's why I'm asking you, because we never,
So I think today being a light day is an anomaly.
okay. So we'll wait, just keep your ears open, and if you ever get to the point where you go, we're wasting 30 minutes, yeah. Sure, please.
actual plea agreement in your pending queue.
Okay. I will double check on that. So it's in the queue.
Judge, this is Sally, S-A-L-L-I, before the court, and case number 11 CF 1568.
Yes, sir.
Mr. Sally is here in a violation of probation. We've reached an agreement. Mr. Sally is going to be admitting to the violation of probation. The agreement that's been reached is that Mr. Sally, who's previously been adjudicated guilty and previously served a prison sentence, would be admitting to the violation of probation and reinstating the probation to complete the original requirements. Now, the original requirements in this case is lifetime probation with lots of restitution. And we're going to modify to include a term of 120 months Department of Corrections with credit for all time served, with credit for all time served. That time served is to include the prior DOC sentence, and it is to include time spent incarcerated from the date of July 16th, 2022. Madam Clerk, are there any issues with that wording? Okay. There's a $100 VOP fee and $150 public defender fee. May I approach with the plea agreement signed by myself, my client, the state, and a score sheet?
Yes, sir. Thank you. Sally, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you, sir. You can put your hand down. Mr. Sally, did you read the plea agreement?
I did.
Do you understand?
I did.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
He did.
Are you satisfied with his representation?
I am.
Did you sign the plea agreement?
I did.
Mr. Sally, I do accept your plea. You're adjudicated guilty. Your current supervision is reinstated with the original terms and conditions. You're also sentenced to 120 months with the Department of Corrections with credit for all time served. The credit for time served to include prior DOC sentence in 46-11 CF 1568 and credit for time spent incarcerated from the date of July 16, 2022. You'll need to pay the $100 VOP fee, $150 public defender's fee, so you'll pay those during your supervision.
Yes, sir.
You do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do, sir.
Thank you, sir. Good luck to you.
Thank you, sir.
Judge, while we are here, in going through the violation report, I did notice that costs of supervision were imposed in his lifetime probation. There is a substantial amount of restitution in this case to the tune of probation. How much is the restitution?
Right now, about 175,000 in Okaloosa, and there's like 150 something coming for Walton.
I know that Mr. Sally is going to be working for a very long time towards paying off restitution. We would ask the court to consider waiving the cost of supervision in the lifetime probation.
The state would have no disagreement with that, Judge.
Okay, so waive any arrearage and also the prospective?
Yes, Judge.
Okay?
Yes, Judge.
Yes. So the cost of supervision waived
Thank you, Judge.
prospectively and retroactive.
Thank you.
Thank you, sir.
Next is Zachary Willis.
Judge, this is Mr. Zachary Lamarck Willis before the court in 21 CF 2708 on felony violations of probation, 20 CF 3102 and 20 CF 1450. Do you have any questions? Yes, sir. This is a copy of the exact. Okay. Okay. And then you can keep this copy. And Judge, over the break, I did prepare a plea agreement that's typed so that we can read it. Mr. Willis is signing the plea agreement at this time. I've advised him at the jail yesterday and here at the courthouse today. Mr. Willis does have a federal sentence, which is part of the reason for this plea agreement here today.
Judge, this is an agreed upon downward departure. As Mr. McKinney stated, Mr. Willis has a prison sentence from the federal court regarding the same charges.
The agreement with the state in 21 CF 2708 would be a plea as charged in counts 1 and 2. Count 1 would be noted that it would be constructive possession of a firearm. Count 3 and 4 would be lesser included offenses of sale, manufacture, deliver, a second-degree felony. Count 5 would be pled as charged. In the violations of probation, Mr. Willis will be admitting the violations of probation in 20 CF 3102 and 20 CF 1450. The agreement with the state is for an adjudication of guilt in all counts and all cases. And that is due to the federal sentence that we've talked about here in court. It is a time-served agreement. There is no probation or further incarceration for the state. The probations would be revoked and terminated with court costs. Madam Clerk, I believe the court costs are $1140 in 21 CF 2708, and there's a $100 VOP fee in each of the VOP cases, a total of $350 cost of defense. May I approach with the plea agreement?
Yes, sir. Mr. Willis, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. Mr. Willis, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Willis, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served. Your prior supervision is revoked and terminated. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You need to pay a total of $350 in public offender's fee, $100 cost of prosecution for each of the 2 VOP cases. Mr. McKinney, do you want the outstanding financials to immediately go to lien?
Yes, Judge. He does have a 10-year sentence on the
So,
federal
Mr.
side.
Willis, all of the outstanding financials will go to a civil lien or judgment, not criminal, but civil, okay? Thank you, sir.
I have one that would be Ms. Goodman.
Okay, from shortest to longest, which case are we going to take next?
I would assume Ms. Goodman's case.
Okay,
Ms. Goodman?
this is Tyler Scarborough,
Yes, sure.
22 CF 418. Hello, Mr. Scarborough.
How are you doing today, sir?
Doing well, how are you?
Doing all right, sir.
Your Honor, Mr. Scarborough is here today for sentencing on a fleeing and leaving. He also has a traffic citation that we need to resolve today. We've received and reviewed the pre-sentence investigation report. There are no errors or corrections that need to be made. We've also received and reviewed the state attorney's recommendation. At this time, we would ask you to follow the probation's recommendation, withhold adjudication, sentence him to 2 years of probation, 50 hours of community service work with an option of buying out at $11 an hour, attend and complete MAD, continue his mental health treatment and at a facility near where he's stationed, or if he's released from the military, that he do it at his home base. And I believe that was their recommendation.
Okay. To the state?
Judge, you should have also received a copy of the state sentencing letter.
I have.
Judge, Mr. Scarborough statutorily is prevented from receiving a withhold on these charges. Under the statute for fleeing and leaving, it's a mandatory adjudication. I outlined all of that information in my sentencing letter, Judge. Just the only other thing that I would add, Mr. Scarborough had been requesting leniency in that pre-sentence investigation, and in the state's opinion, Mr. Scarborough has already received an extreme amount of leniency. He's had ample amount of time to get his affairs in order before serving what the state would request of the 6 months county jail. I have never seen this court allow a defendant to be released on bond pending the sentencing after a jury verdict. So the state feels that he's had time to get things ready and get prepared for what the state feels is appropriate for this case.
Okay. And you addressed the adjudication of guilt in your letter?
Yes, Judge. If you look at the last paragraph,
Yes.
it explains that statutorily he has to be adjudicated. His driver's license will have to be suspended for a minimum of 1 year and up to 5 years. It also contemplated that the motor vehicle that was used in the flight could be taken and seized. However, the state's not asking for that. My understanding was the bike was totaled that night, and so we're not asking for that to be imposed.
Okay, thank you. Ms. Gooden, anything else?
Correct. It's the adjudication is within the court's discretion. He wasn't driving recklessly. He wasn't found guilty of driving recklessly or causing an accident or harm to anyone else. The court does have the discretion to withhold adjudication. As far as the traffic citation, we would ask the court to withhold and assess a fine or merge and dismiss with this case.
Okay. Let me ask the state on the CT case. What do you wish to do?
Judge, merge and dismiss would be appropriate.
Okay. Okay, so then I've got a dispute in law whether I can adjudicate, well, whether I can withhold adjudication or whether he has to be adjudicated. What authority does the state have?
775.08435, prohibition on withholding adjudication.
That's not explained. And to be honest with Your Honor, I didn't research.
It's under the fleeing and looting statute, Judge.
So Ms. Gooden, how do you just say it's within my discretion if you don't know? You're making a representation to the court that you do know when you say, especially after the state says you don't have, I don't have discretion to do that, so explain that.
And I didn't bring case law that says In my reading of the statute, you have the discretion to withhold adjudication.
Okay, big difference between what you just told me. In the beginning, you said, I've got discretion, then you said, I don't know, and now you're saying I didn't research it, but you looked at the statute. Which one of those is it?
I did not do case law research.
Okay.
Okay.
Did you read the
I
statute?
did read the statute.
Okay.
My reading of the statute, it is within your authority to withhold adjudication of guilt.
Okay, thank you.
And I will, I'm trying to pull it up now.
It's 316.1935, fleeing or attempting to elude a law enforcement officer. Under subsection 6, says, notwithstanding section 948.01, no court may suspend, defer, or withhold adjudication of guilt or imposition of sentence for any violation of this section.
Okay, and so it's not 775, it's
No,
316?
I'm sorry, Judge, it's under the actual fleeing statute, 316.1935.
Thank you. In the future, Ms. Davis, if you want to put that cite in your letter, that would help us.
Yes, Judge.
Thank you.
Your Honor, in the 316.195 is parking regulations,
316.1935.
1935.
I was just looking at the verdict form to make sure the jury found Mr. Scarborough guilty of that crime. Mr. Scarborough, when I was doing my homework, I just made a note that said, you know, do you know the power to make decisions over you that you gave up that night? I mean, by your actions. What's good for the court is, you know, I feel comfortable sentencing after a jury trial because I've heard everything. A lot of other sentences, if it's straight up, I read what's in the papers, I do different things, but I don't hear all of the evidence that goes to the fact finder, the jury, and so it's nice to have that. You know, driving a motorcycle at over 100 miles an hour, the risk to society, the concerns that the court has for that. All that being said, Mr. Scarborough, if I had the ability to withhold, I would withhold. I don't. So you're adjudicated guilty. You're sentenced to 3 years probation. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll have no alcohol during your supervision. Submit your random breath test. Your driver's licenses are revoked for 1 year. You'll need to successfully complete the victim impact panel. Perform 50 hours of community service work. Your attorney has to buy that out. You can't buy that out. I want you to do that work.
Yes, Your Honor.
The state, well, and I may have seen this in the pre-sentence investigation. When I was doing my homework, I made a note that said any evidence for need of mental health treatment, but I believe I may have read something later that talked about that. To the state, why should that be a requirement?
Judge, that was something that Mr. Scarborough makes allegations of needing and doing in his note in the pre-sentence investigation.
Okay, thank you. So you'll need to continue your current mental health treatment and follow any treatment recommendations. Court has no objection to you transferring your supervision to Texas. You will need to complete the MAD program. It's $40 per month cost of supervision in Florida. If you transfer to Texas, it may be a different amount. Mr. Scarborough, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, Your Honor.
Thank you, sir. Good luck to you, sir.
Thank you, sir.
Thank you, Your Honor.
Did Your Honor receive a copy of the score sheet?
If I did, I didn't print it off. Thank you, Ms. Gooden.
Thank you, Your Honor.
May I bring that over? Certainly. Allison, since it appears you're calling the docket, who's next?
11.
Thank you. Mr. Levin's case is 17 CF 2720. Hello, Mr. Levin.
Your Honor, this is Douglas Levins in 17 CF 2722. I did meet with Mr. Levins yesterday and explained what I am intending to do here. This morning I talked with Ms. Samuel with the State Attorney's Office, and I'm going to confer with her and Mr. Gomez on a proposed order for the court to order the Sheriff's Office to transport Mr. Levins to have his Baker Act evaluation. Quite frankly, I would expect the order is not going to be complied with, but it's step one in filing a motion for an order to show cause. This has been going on since last June, and something has to happen.
And an order hasn't previously been entered for that?
I don't believe specifically directing the Sheriff's Office to transport. And so I want to make sure we have the language in the order correct. That's why I have a copy of the proposed order, but I talked to Ms. Sandler. I sent her an email a little while ago saying we need to talk about this because I think there's some additional language that needs to be in here. So probably tomorrow the court's going to get submitted an order from the parties ordering the Sheriff's Office to transport Mr. Levins for this evaluation. I can tell the court that he was actually transported to a hospital for a medical reason not too long ago, and for whatever reason, they still didn't Baker Act him. And so I have made it clear to the state, essentially, that even though Mr. Levins is okay with this, the jail is not a hotel.
And at some point, if he's not going to be Baker acted, then he needs to be dismissed, he needs to be released. So we will be submitting an order for the court. I would ask the court to put Mr. Levens on for a status date. I know Madam Clerk had already indicated the 16th is chock full of people.
Well, it is for evidentiary things.
If we want to keep him on the morning docket for a quick status.
Let's
Okay, and we will get that order submitted over to the court. And I would love for him to be transported. I don't want to have to file the motion. If the sheriff's office says, yeah, we'll do it, we're just waiting on the order, then great. I just want to try to get him out and on the way to the rest of
Understand.
his
So
life.
you're going to get me the order to transport before March 16th?
Absolutely, probably before the middle of next week.
Good. So, Mr. Levens, I'll see you on no later than March 16th.
What is it today?
Today is the 23rd of February.
I'm worried about is I have no place to go.
Understand.
Where should I go?
I'll come talk to you at the jail, okay?
Like, where should I go?
Right now, you should go back to jail, and then I'll come talk to you, okay?
I mean, I'm scared. I don't know you. I'll come on.
Mr. Levens, nothing's going to happen. You're not going to be you won't be removed from the jail unless well, even if they take him for Baker Act, then he'd be held in the hospital, correct?
Correct.
And then if they release him from the hospital, he'd go back to the jail, right?
If they did the evaluation and the actual professionals in the Baker Act wing said, we don't think he fits the criteria, I think he would be discharged. But at this point, even if Mr. Levens wanted a place to stay, again, we're back to the point of the jail cannot just keep him until he's ready to live on his own.
Understand. But so doesn't something have to happen to this case before he would totally be released?
I would imagine. I mean, I'm kind of getting ahead of myself. I don't think, I guess in hindsight, the way you put it that way, yes, I do believe if he was Baker acted and they said he's not a candidate, then I think he would be returned to the jail because then he'd have to be in front of the court for a dismissal.
And if he did qualify for Baker Act, they would keep him for whatever period of time, and then when they released him, he would still be under this case, right?
In talking with Ms.
Unless I
Sandler,
sign an order that says something else.
I believe that the state's intent would be if he is Baker Act committed, the state would file a null pros at that point.
Okay.
And so Ms. Sandler had indicated either way the charges are going to be dismissed. It's just either he's going to be in a facility being Baker acted, or if those experts say he's not qualified, we don't need to Baker act him, the state's going to dismiss the charges either way. It's just, I don't want Mr. Levens living in the jail.
Right. Okay, Mr. Levin. I should see you back here on March 16th unless the state dismisses the case before then. Okay? Thank you, sir.
Thank you.
No. Status. Allison, who's next?
Do you want a sentencing hearing, or do you want the Nelson hearing first?
Let's do the Nelson hearing probably the last.
Okay. And then Tilden.
Okay? Good.
Tilden?
Hello, Mr. Tillman.
Hey, Judge Brown.
Judge, this is Mr. Sean Tillman before the court. Mr. Tillman is here in two case numbers, 22 CF 1348 and violation of probation 18 CF 2512.
I've read the state's letter and your letter. Well, Ms. Davis's letter, right, and then the public defender's letter. Let me ask this to Madam Clerk. I didn't see where a verdict form was filed in this.
I did see one filed in the bench
good.
mark, Judge.
Okay. I saw the minute sheet that said it, but I didn't see the verdict form. So just wanted to make sure there was
The
no,
verdict form is in 22 CF 1348, not the.
it's probably looking at the other. Good, thank you, ma'am. Okay. Mr. McKinney?
Judge, I did want to take some brief testimony from Mr. Tillman.
Good. Mr. Tillman, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
So help me God.
Thank you, sir. You can put your hand up.
Mr. Tillman, could you please state your name for the record?
Sean Christopher Tillman.
And sir, were you previously sent to prison in one of these cases?
Yes, sir, I was.
And that was followed by probation.
Yes, sir, it was.
Upon getting out of prison, what did you do to get on your feet last time?
I went to my mother's house and got a job Within 3 days of being out.
Where were you working at?
The Wyndham Garden Hotel on the island.
What were you doing there?
I was a cook.
And you stayed living with your mother until this arrest happened back in last May, is that right?
Yes, sir.
In getting out, whenever you're released from incarceration, is it your desire to go back and live with your mother in Fort Walton Beach?
Oh, absolutely.
And are you fine to stay there?
I am fine to stay there.
And is it your goal, once you get back out in the community, to obtain a job again and get back on your feet?
Immediately.
Has this almost last year in jail given you a wake-up call on how drugs affect your life?
Memento mori.
And do you think that you are thinking clearly here today?
Yes, sir, I do.
Do you believe that you have any intention to get back to the outside just to go do more drugs?
Absolutely none at all.
So do you believe that you're in a good place in your mind right now if you were to be released?
Clarity.
Part of when you're on the outside, can you explain to Judge Brown what's going on with your father?
My father just, back in 2020, 2020, I said that wrong. He had a stroke, another one, and then when I was at work release, he had another one. He had his colon removed, cancer, and then chemotherapy after he just got off of that last March. So, I mean, but he's up and down, and there's not really, any telling, how he's going to do from day to day.
When's the last time you saw your dad?
2012.
Does he live in Mississippi?
Pascagoula.
So part of your desire once you're released is you want to see your dad.
Immediately.
So obviously you know that if you're on probation that's going to be problematic, or you will at least need to get a travel permit if you're going to visit Mississippi.
Yes, sir.
So is that part of your thinking in your decision-making process when you're asking this court for a sentence?
I'm willing to work with the state if the state's willing to work with me.
I mean, at this point, do you want to be placed on more probation?
I'm afraid to.
It's up to you. I mean, it's your decision. At this point, I guess I'll rephrase that question. Have you spent a lot of time in prison and in jail at this point?
Yeah.
Do you want to move on with your life?
Yes, I do.
I have no further questions for Mr. Tucker.
Any questions from the state? Any other evidence, Mr. McKee?
No, Judge.
Any evidence from the state? Argument, Mr. McKee?
Obviously, this court sat through the trial. It was able to hear Mr. Tillman testify from the stand. It was able to see the videos of exactly what happened. The court got a snapshot of what happened on that day and can certainly work off of that. So Mr. Tillman has spent a lot of time in the Department of Corrections and a lot of time in jail for this case. I'm just asking the court to take that into consideration. The score sheet that I was provided by the state is different from the numbers you see in my letter slightly, because it includes 12 bonus points instead of 6, which is what I'd calculated when I wrote my sentencing letter.
Okay.
That's based on Mr. Tillman being a violent felony offender of special concern. That score sheet shows a minimum guideline sentence of 34.5 months in the Department of Corrections is the lowest permissible. Mr. Tillman has already served a full 9-month Department of Corrections sentence in 18 CF 2512, and on top of that, he's been in jail for 9 months from last May when he was arrested through a jury trial, and obviously he's been incarcerated since then. So, I mean, altogether, he's got about 58 months credit if you add the two of them together. We're asking the court to take that into consideration, sentence him to the minimum guidelines, and revoke and terminate the probation. Yes, that would equate to effectively a time-served sentence for Mr. Tillman. But our position is that he has served his time for this. This is not a position where he has not been in jail while he was waiting to get to trial. He's been in jail since May 15th of last year. I believe that Mr. Tillman, based on his testimony, is thinking clearly. He's expressed a desire to me that he doesn't want to get back on drugs. He doesn't want to go back into that lifestyle. that he wants to get out and be a productive member of society. He wants to get out and he wants to get a job. He wants to get out and see his dad. He wants to get out and do normal things. When you look at the violation of probation paperwork, he paid his restitution. He paid his court costs. And then this violation happened because of the new charges. The court saw what happened, so we're asking the court to take that into consideration in sentencing.
Thank you. To the state.
Judge, my problem is the disingenuousness, it feels, of what Mr. Tillman's testimony is. Mr. Tillman was on probation for 2 counts of battery on a law enforcement officer. He was then sentenced to prison because he got a new charge of burglary of an occupied dwelling. So this isn't that he's, just this victim of the system. I mean, he went to prison because he committed charges that were even more violent than the last violent charges that he had. So what the state feels is that Mr. Tillman is a danger to the community. So on this case, Your Honor heard the testimony that came in. Your Honor is aware of the situation, the way that Mr. Tillman was attempting to get into this residence with a family at home. I do want to make clear for the record, I informed them that the sentencing hearing was today. Mr. Tillman clearly demonstrates that he is a danger to his community. He cannot do it on his own. Mr. Tillman had the opportunity, and he's saying that, okay, I got out of prison and I got a job in 3 days, but I want to go get a job. Well, and he's done that, and he still chose to celebrate the Billy Bowlegs Festival by getting so high that, if that's all true, that he's so high that he tries to break into this family's house.
Ms. Davis, let me ask you a question. In your sentencing letter, you say 40.5 months DOC credit.
It should be 34.5 if you look at,
Okay, but with credit was my question. With
Yes,
credit
Judge.
for all time served?
Yes, Judge. My concern is much less as far as him going back to prison. But essentially what Mr. Tillman is wanting is he's wanting a benefit that he picked up new charges when he was out on probation for only 2 months. So he's wanting to go to prison, supposed to be on 5 years probation, get out, get super high at Billy Bowlegs, and then not have to do his 5 years of probation. So the state doesn't feel that Mr. Tillman's going to be able to stay sober on his own. Probation is not sufficient to monitor Mr. Tillman and assure the community that he is not going to be a danger to the community. The state feels that for Mr. Tillman that we need to make sure that he does his guidelines DOC sentence, which is essentially a time served, but then when he's released that we really need to step this up because Mr. Tillman is too dangerous to just be on probation. So he needs to be on 2 years community control and then 5 years probation following that.
When you said weekly urinalysis, usually it's random urinalysis. So weekly, it's going to be random weekly urinalysis?
You can get information on how they work it out as far as what days. Typically, when he would check in on Tuesday, they would do the urinalysis at that point if it's weekly. But
then he knows when they're going to be doing the urinalysis.
But the state doesn't feel that random urinalysis is going to be sufficient to ensure that Mr. Tillman is not engaging in this criminal activity.
Okay, thank you. Mr. McKinney, anything else?
Judge, the state uses language like break in and trying to get in. That's not what the jury found here. They found trespass.
Yes, sir.
The state believes that Mr. Tillman is trying to get a benefit from this sentence. I don't think that most people are going to believe that additional jail time is a benefit. He's been in jail for over a year just pending these charges. And to get here to this sentencing here today. So we would stand by our request of the court.
Okay.
There are portions of the violation of probation statute that would be applicable in this case that the court should be aware of, specifically related to the score sheet as we start to look at the 12 bonus points that are on there. I believe that if the court looks at 94806, 8D, E1, and to explain to the court what that is it says that the court, after conducting a hearing required by paragraph D of that section, determines that a violent felony offender of special concern has committed a violation of probation or community control other than a failure to pay costs, fines, restitution, the court shall make written findings as to whether or not the violent felony offender of special concern poses a danger to the community. In determining the danger for the community, it lists out A, the nature and circumstances of the violation, the offender's present conduct, including past convictions, the weight of evidence, and any other factors that the court considers relevant in deciding whether or not he's a danger to the community. So I believe that if the state is seeking to include those violent felony offender special concern points on the score sheet, the court has to go through that analysis and make written findings whether or not Mr. Tillman is a danger to the community or not. I don't think it really has an impact on the sentence at the end of the day. But I do believe if we're going to follow the statute, the court would need to do that.
Thank you. Mr. Tillman, listening to all the testimony that the jury hears really helps me with sentencing because I've heard everything.
Yes, sir.
One of the things that I don't even know how to describe it was very hard for me to understand was the testimony that you knew that by taking the fentanyl that you were putting your life in jeopardy and you were going to be there with, you had to have somebody there, a friend there with Narcan to bring you back, basically bring you back to life.
That happened, yes, sir.
Unbelievable to most of us that somebody would put themselves in that position.
Yeah, I didn't think it was going to happen.
I do understand, the facts of how you ended up behind that house. I mean, I believe most of what you were selling in that, as far as, and that's selling in quotes, most of what you were trying to convince the court of and the jury of. And that may have been why the jury ruled their verdict was the way it was. I agree with that. I don't think that you intentionally were trying to get into that house. I do have concerns that because of your prior drug use, there's got to be some supervision over you to make sure that you're clean, that you're sober. What I'm putting of record is, and so Mr. McKinney may want to get just that portion of it and put it in your file or give you a copy of it, is that if you make it through half of the supervision time that I am sentencing you to, and you don't have any violations of probation, any of those things, I encourage you to go to the judge, whoever that is at the time, and ask to modify your supervision.
Yes, sir.
You're adjudicated guilty, you're sentenced to 34.5 months with the Department of Corrections with credit for all time served, which includes the prior DOC time and the time in the Okaloosa County Jail. That's followed by 2 years of community control, and that's followed by 5 years of drug offender probation. For the first 2 years, you will need to submit to weekly urinalysis. After that, if you haven't violated probation, then it will be random urinalysis for the rest of your supervision. You'll need to attend NA meetings weekly. Your prior supervision is revoked and terminated. However, the original terms and conditions are reimposed. You need to pay the $100 VOP fee. the $150 public, well, no, there's all monetary assessments mandated by statute or county ordinance are imposed. That's the court costs on the new case. And then there's $150 public defender's fee. There's also $40 per month cost of supervision.
Judge, that would be on the VOP case, is that right? On 18 CF 2512?
The $100 VOP fee, yes, ma'am, is on that. So it's a total of $250 public defender's fee.
As far as the DOC and the supervision, that's all within the VOP case.
Yes, ma'am.
So then the new case is just a misdemeanor charge.
And that, we're just merging it, we're dismissing?
No, Judge, what the state was requesting is an adjudication of guilt and a concurrent one-year probation.
Yes, ma'am.
With the VOP.
In the new case, 22 CF 1348, you can tell I was focusing on the other sentence more than I was this one. You're adjudicated guilty, you're sentenced 1 year of probation, but it's to run concurrently, run at the same time as your the first year of your community control. You'll have no contact with the victims, no trespassing at the victim's residence. You'll have weekly urinalysis, weekly NA meetings, the $275 in court costs. Mr. Tillman, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir, I do.
Thank you, sir. I wish you the best.
Thank you.
Probation.
Did you say this, after the 60, it's 4 years of dock?
5 years.
5 years of dock?
I think that would have to be 24 months followed by, is the maximum drug offender probation 24 months?
There's no maximum.
Is the maximum? Okay.
So do you want to come to the
Yes, ma'am.
monthly UAL dock?
7 p.m. to 7 a.m. subject to work. Okay, or school if he decides to go back to school.
And Judge, while we're here and we're talking about it, does the court have an opinion on whether or not there should be a travel permit once he's released, on whether or not you can go visit his dad in Mississippi? Because I know that's important to
On
him.
community control, I don't think that's going to work.
Something else, right. Thanks, Judge.
Mr. Tillman?
Judge, I have a score sheet if you'd like me to refer.
I know.
Your Honor, the score sheet.
Please. How you doing? Good. Mr. Klein?
Your Honor, this is Mr. Walter Moschel. He was before the court in 22 CF 1767. We had filed a motion. I had styled that motion a motion to set aside verdict. And in reviewing the state's response to that, I do agree primarily with the original. Right off the bat, the state essentially points out, well, what rule of criminal procedure is this motion being filed under? I think that's a fair point to make. In preparing for the hearing today, I did come across a case that is mentioned by name in the case that we cite in our motion. So in our motion we cited to the State versus Kelly decision. Reviewing the Kelly decision, I came across a decision that's cited in Kelly, State versus Capallo, which is 932 Southern 2nd 331. And what happened in Capallo is that the defendant filed what was referred to in that ruling as a motion for a judgment of acquittal / motion to set aside verdict. I think that's a more accurate description of what this motion is, because I did take pains, and as the state did point out, and I 100% agree with this, I am definitely not asking the court for a new trial here. Our position is pretty basic, and it's described best in Capallo. Our position, Your Honor, is number one, strangely enough, this type of factually versus legally interlocking inconsistent verdicts not discussed in law school. And I have a feeling most attorneys don't really know much about it until they're presented with the problem that it involves. This is certainly the first time in my career that I've ever dealt with this, and I essentially did not know how to respond. I can tell the court my personal beliefs. When the verdict came back, I was mainly satisfied that we had avoided the designation. That was, and that, to be completely candid, that was the basis for my advice to Mr. Moschel to accept the plea, or to accept the verdict as is, because we had avoided the designation. However, after, the weeks after we had this happen, I started going back and I looked at inconsistent verdicts. And essentially there's a difference between a factually inconsistent verdict and a legally interlocking inconsistent verdict. Generally speaking, Florida courts will accept factually inconsistent verdicts. And that's generally because we don't know what the jury ever talks about back there, but we'll just assume that if it's factually inconsistent, they're probably exercising some kind of rule of lenity. However, Capallo really does a better job than Kelly in describing what an impermissible, inconsistent verdict is. And in Capallo, it says, quote, for example, the verdicts are impermissibly inconsistent where a defendant is convicted of a felony murder but convicted of only a misdemeanor rather than the underlying felony. Or where a defendant is convicted of possession of a firearm during the commission of a felony but convicted of only a misdemeanor rather than the underlying felony. And when I read that, that struck me as that's exactly what the position is that we're in here, is that by rendering the verdict on count 1, the count 2, that lesser included, the full statute is unlawful use of a two-way communication device to facilitate the commission of a felony. That's one of the elements in the actual instruction for that particular charge.
And it's in the verdict form.
Correct. And so our position, Your Honor, is that this is the motion for judgment of acquittal as to count 2 only, based on the fact that these are impermissible, inconsistent, legally interlocking verdicts. There is no underlying other felony, just like there would not be any other underlying felony in that felony murder situation, or using a weapon in the commission of a felony. If there's no underlying felony, Capallo very clearly says that those are inconsistent and improper verdicts. And so our position, Your Honor, really kind of best explained by Capallo, is that the court is faced with that exact situation here. We are asking the court to enter a judgment of acquittal just to count 2.
Okay, thank you. To the state.
As Mr. Klein said, I know the court's very familiar with this case, so I'll be brief. State's position is that defense's filing was not timely or specific in this particular case. Because defense specifically requested the lesser included that he was eventually convicted on. That was a lesser included that is not on the Florida Bar website as a category 1 or 2. The state objected, and over the state's objection, it was allowed. The difference in the cases cited by the defense and the facts at issue here is that they don't usually include the lesser includeds that were not in the standard jury instructions that were requested by defense and included. But for that misdemeanor that defense requested being within this lesser included, we wouldn't have this inconsistent verdict, essentially. Essentially, defense in being acquitted of the sex offense already had the benefit of the bargain of that lesser included. So at this point, to come back and now say, well, because of the lesser included that we wanted, well, now the verdict's legally inconsistent, doesn't seem fair between the parties. Defense and state agreed when the jury question came in that the court should not inquire regarding any further information with them, regarding whether the solicitation of the prostitution was a felony or misdemeanor. So at that point, because we didn't go forward with inquiring of the jury, I believe that right to challenge that had been waived. Of course, the court, the state, and the defense, we cannot get in the mind of the jury, so when they did come back in with their inconsistent verdict, they had to believe in good faith that they had met all the elements and proof to support the evidence based on what they had of the crimes before them. In addition, regarding inconsistent verdicts, under Turner, it was noted that defense has a number of constitutional and procedural safeguards in place to assure that convictions are not erroneous, whereas the state does not have the benefit of many of those reciprocal protections. So state's position at this point would be the objection to the question by the jurors or the inconsistent verdict was waived by defense requesting the lesser included, but for that lesser included the state objected to, that was not within the standard instructions by the Florida Bar, we wouldn't be in this situation. They've already had the benefit of the bargain in not being convicted of a sex offense, so we'd ask to proceed to sentencing.
Okay, let me ask you this question. When you said something like the jury in good faith believed, will you finish that sentence? Believed what?
So I believe the jury in good faith had to believe, based on the evidence before them and the elements they were given by the court, that this was the verdict and sentence that they were comfortable with. They wanted more information from us. We didn't give it to them. So again, we can't be into their mind. We can't go into the minds of the jury, but based on the information they had, that was the verdict that they returned. And I know in a lot of instances, because there was no contemporaneous objection at the time, and I don't believe there was any polling of the jury, that objection was waived. So to come back how many days later when the jury is long gone, it seems to create a problem.
Okay. Thank you. And I appreciate your response to the defense's motion. Certainly opened my eyes to a lot of things, and I appreciate it. Thank you. Yes, sir.
Yeah, just briefly, I understand the state's argument regarding certainly they objected to the giving of the lesser included instruction on count one. However, it's generally well settled in the state of Florida that a trial judge has to give a jury instruction on a permissive lesser included offense if the following two conditions are met. The indictment or information must allege all the statutory elements of the lesser included offense, and there must be some evidence deduced at trial establishing all of these elements. It seems to me that the state's position is essentially a defense attorney has to decide to commit potential ineffective assistance of counsel and not asking for a possible instruction in the offhand chance that there might be some kind of inconsistent verdict coming back based on that. I don't necessarily think that that's really truly the case. I don't really see too many courts saying, yes, a defense attorney or any attorney really should have to decide between ineffective assistance as a trial strategy, intentional trial strategy, in the very unusual situation where an inconsistent verdict might be triggered by that. So I don't believe that that's really an appropriate position to take on the law. I think I would point out that Ms. Barrickman is saying, I believe the jury does. I have my own personal beliefs about what the jury probably did and why, but I'm not the jury, so anything that we're talking about, I believe the jury did this or that, is speculation. The jury was the fact finder in this case. The primary offense here was traveling to meet a minor to engage in sexual conduct. That was a second-degree felony. The jury listened to the evidence and found Mr. Moschel guilty of a misdemeanor. Our position is that, as it's explained in Capallo, this is exactly like felony murder when the underlying felony results in a misdemeanor conviction. Then it can't be felony murder. And same with the possession of a firearm during the commission of a felony. The Kelly case itself is talking about exploitation of a elderly victim and grand theft. And Kelly talks about the fact that the state did not charge Kelly with multiple counts of theft or exploitation. Rather, Kelly's actions across multiple dates and involving multiple bank accounts were charged as one episode. As a result, the acquittal on the theft charge negated the necessary element of theft in the exploitation account, making the two legally interlocking. So our position is that because the jury came back on count one and found him guilty of a misdemeanor, count two's conviction on the lesser included is necessarily a legally interlocking, inconsistent verdict. And based on Capallo and Kelly, the court should enter a judgment of acquittal on count two only. And the defense is ready to proceed to sentencing on count one.
I understand. Thank you. Mr. Moschel, I've never been on the bench and had 3 sentencing in one day, all arising from jury trials that I was the judge. I'm smiling because I know all the things that happened during the trial. It's wonderful. Instead of hearing arguments and seeing things in writing, I saw the witnesses. And at the time, I raised concern about the jury's question. The stating speculation, I think we saw a little bit into the mind of the jury by their question, which was, can we clarify that count 2, guilty of unlawful use of a two-way communication device to facilitate the commission of a felony means prostitution only? So I think we know a little bit more about what the jury's thoughts were, and it's not just pure speculation. I should have, at the time that I got that note, I should have slowed everything down, and we really should have taken longer, the attorneys in the court, to look at that, because I didn't come up with what may have been a valid way to respond until after we got word that the jury had a verdict. I asked the attorneys at that point, and they said, no, we want to hear the verdict. So I didn't pursue that anymore, and I understand that. But I have a civil background, and so when I hear a waiver, under contract law and those things, waiver has to be intentional. And you have to find that someone really intended to waive something. In criminal law, I don't think it's that strict. The word estoppel hasn't been used, but to argue that the defense is stopped from raising this because they asked for the lesser included or agreed to not sending back anything in relation to that question from the jury, I do not find that. I don't find that the defense waived or is stopped from raising this motion because of that. I do find that the verdict is an interlocking, inconsistent verdict, and the motion for judgment of acquittal on count 2 is granted. So as far as sentencing, Mr. Klein?
Your Honor, given the fact that the court has granted the motion, Mr. Moschel is before the court now on 1 first-degree misdemeanor. I can just very briefly explain to the court my position on this. I don't want to take up too much time, but I know Mr. Moschel and I have a disagreement about this, and I definitely want to put his position forward. So Mr. Moschel was convicted of a violation of 796.07, subsection 2F, which is if it's unlawful to solicit, induce, entice, or procure another to commit prostitution. I have reviewed all of the case law on this particular statute. Mr. Moschel takes the position that he's actually should have been convicted of subsection I, which is to purchase the services of any person engaged in prostitution. I don't think that the facts that the jury heard support that. And the way I read that is that it's one of those weird positions of the law where it's almost better to get caught after you already have, I hate to say it this way, but after you have the prostitute in the car, because that's a second-degree misdemeanor. And while they're still out of the car and you're discussing terms, if you get caught, that's a first-degree misdemeanor. It's almost like the law is flipped a little bit, kind of how like there's a driving with suspended license, 10-day jail minimum mandatory on misdemeanor offenses. But if you're charged as a habitual traffic offender, there's no 10-day minimum mandatory. And so Mr. Moschel takes the position he was convicted under I, and this should be a second-degree misdemeanor. I wanted to make the court aware of that just in case the court agreed with him. I don't agree with that. I don't think that that's the way that this is written. I don't necessarily agree. I mean, clearly the investigator was not an actual prostitute. I can tell the court that Mr. Moschel has been in custody since the day he was arrested in July. I would just like to ask some brief testimony, Mr. Moschel.
Mr. Moschel, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir.
So, Mr. Moschel, if you were released, what are your plans?
To go back to work. I have all my own company.
What kind of company is it?
We work with Hudson Homes. They buy distressed properties and we remodel them and get them ready for sale rate.
Okay, and since you've been arrested, have you lost any business?
As of Monday, $85,500.
Okay, and how quickly do you think you can get back into the swing of things job-wise?
Immediately, if I can get out of here.
Okay, and is your intent to ask the court for a time served sentence here?
Yes, sir.
Okay, are you going to stay in the area, or are you going to go back to Texas?
I'll be all over the work, all over the United States.
Okay, so you have work that you expect to be engaged in as soon as you're released?
Yes.
Okay, I don't have any other questions.
Thank you. Any questions from the state on Mr. Motion?
No, Your Honor.
Any other evidence?
No evidence, Your Honor.
Any evidence from the state?
No, Your Honor.
Argument?
Your Honor, we are simply asking the court, this is a very unusual case. I thought about, at lunch, I thought about saying, Judge, I don't know if you've ever had this situation come up. It is what it is. He's been in jail for 9 months at this point. This is a first-degree misdemeanor. I would ask the court for an adjudication of guilt and time served.
Thank you. To the state?
Judge, state in their letter when it had the felony count still in play was asking for 24 months DOC followed by 1 year of probation. That was based on the 23 some months he scored. At this time, we'd be asking for 1 year of probation, terms to include no internet-capable devices, HIV testing, forfeit seized devices, and no unsupervised contact with minors. The court will recall he did testify that he engaged in several solicitations of prostitutes the day of and the preceding days up to when he traveled, in this particular case, to make the undercover. While the jury found him not guilty of traveling to meet a minor to engage in sexual conduct, he did admit and he was told by the undercover that this was a juvenile, so we would ask for the no unsupervised contact with minors and no internet at this time.
Okay, I'm sorry. Okay, so 1129 probation, no internet access,
Yes.
and what else?
HIV testing, no unsupervised contact with minors, forfeit seized devices.
No contact or no unsupervised?
No unsupervised contact with minors, no internet-capable devices, HIV testing, and forfeit seized devices.
Yes, sir. Mr. Klein, did you get the final word?
Your Honor, Mr. Moschel was just informing me that his job is, a lot of it is based on his ability to connect to the internet. Direct quote from Mr. Moschel here just now was, if you take my phone, you take my job. The court presided over this. I know the state's position on this. If the court remembers, as soon as the investigator said on 14, his first response is, I don't believe you. And this is not a situation where he came up with an after-the-fact excuse that somehow the jury bought. I mean, there was evidence to support this type of a defense here, and that's what the jury found. And so if they found him guilty of a first-degree misdemeanor, we're asking him to give him time served. He's been in for 9 months.
And the reason why I hesitate is my thoughts were, until I heard from the state, to sentence Mr. Moschel to 1129 in Okaloosa County Jail with credit for time served. But I take it that the state wants a full year of probation to keep control over Mr. Moschel versus an additional 3 months or so. Is that accurate?
That's correct, Judge. We'd rather have eyes on.
Okay. Mr. Moschel. Okay, Mr. Moschel, some of the things that I highlighted from the testimony during the trial, from Investigator Teal, Skip the Games is a site primarily for adults. That you said a 14-year-old, I'm here for you, and then you sent a picture of an anatomy part to her. Can you take that? Across the investigator. Online says that the one who you're communicating with is 19 years old. Later, the testimony of that investigator, a quote from you, "Still don't think you are 14, but we will see." Also, his testimony was, or her testimony, Investigator Teal's was, "I don't think you are that young." You testified, I don't know how much credit I give to it, but you said if it was a 14-year-old, then I would have handed her money, but if it was an adult, then I'd have sex with her. And your testimony about using prostitutes in the past and all those things, and the frequency of using that, certainly bolstered a lot of your testimony. Also, your testimony, living in Houston, Texas, traveled here to do construction work, looking for company for that night, prostitute. You also, I believe, talked about the site that was consistent with what the investigator talked about. It was primarily for adults.
Right.
But you did send anatomy pictures to the folks. You did do what the jury found you guilty of. You're adjudicated guilty. You're sentenced to 11 months, 29 days probation. You'll have the subject communication devices are forfeited. You'll have no unsupervised conduct with any minors. You'll have no internet access. You will need to have HIV testing, pay the $150 public defender's fee, and the court costs. There was also, I believe, wasn't there something in here that talked about psychological evaluation and counseling? Wasn't that raised in maybe, I thought I saw that.
Your Honor, in reviewing the statute, if the court is going to impose probation, there's also a mandatory 100 hours of community service.
Okay.
And that would be, give me 1 second.
Okay.
Subsection 5B, number 1 of the statute.
Okay. 100 hours of community service work. Also, Mr. Mojo, I want you to be the best citizen you can be. And so I do order that you submit to a psychological evaluation within 30 days from today. And if any counseling is recommended, begin that within 60 days of today. Mr. Mojo, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. You cannot afford an attorney to represent you for that appeal. One may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Probation?
Your Honor, is he going to live here, or is he going to Texas?
I don't know what's going on.
You've been sentenced to 3 years probation.
Not 11 times.
Not 11. Okay.
I have a job offer here from someone that I was in jail with that I need, because I don't even know my car. If I don't have my car, I don't have the job.
Okay, because he doesn't qualify to transfer out to state on 1129.
Well, I was just going to ask the court to allow this to be supervised by JCS, given the fact that this is a misdemeanor.
Yes, sir. Let's do JCS, because then he may have more flexibility on transfer.
Okay. Because I'm not giving you contact information for JCS. JCS is also information for services. It's not, that's the Department of Corrections. Your Honor, the one thing I would ask is if Mr. Moschel finds that the no internet the no internet access is prohibitive on his business, I would ask that at least allow Mr. Moschel to petition the court upon a showing of hardship to maybe modify that within 60 days.
Yes, sir.
Well, Your Honor, what's the deal with the company we work for is out of California? And when we do these jobs, we take pictures of what we've done and send it to them. That's how we get paid. They don't come do the job.
Maybe you and Mr. Kleins can come up with, or with probation, you can come up with something that that would be in between. Whether you take the picture and you get somebody else to send it,
Yeah, I don't want to violate like that. You know, I mean, in case that's specific, I don't want to.
no, I don't want you to do anything illegal,
No.
but just think about any way that you may be able to accomplish your job without that access. Thank you.
And Your Honor, for the record, the state would respectfully object to granting defense's motion for JOA.
Yes, ma'am. Thank you.
All right, then we can put this call out, Randy, put that to attention. Call it tomorrow, it's probably until we call it next week. We'll call it.
So the last person that's in the gallery ward,
We got two on the 1:30 docket, hit flat tire on the way here, so we got your rate.
okay,
What's your name, sir? Mr. McElroy?
Oh, that's mine.
Bring it back.
Elijah, it's 23 CF 175. Mr. McElroy, the caveat is withdrawn, so they won't arrest you today, okay? Thank you for showing up, it's a big deal.
Yes, sir. Yeah, we do have a one-count information. We will enter a not guilty plea and ask this remain set on the 313 docket.
Okay. So, Mr. McElroy, I'll see you back here on March 13th at 9 o'clock. Stay in touch with Mr. Williams, okay? Thank you, sir. It may take longer. How long do you think?
Your Honor, I reviewed his motion, and I believe it's based on the outdated rule of procedure, so I don't know. But I don't know.
Okay, let's try. Yes, sir.
Your Honor, this is Mr. Losey. He had filed a motion for Nelson hearing.
Yes, sir. Mr. Lucy, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, Your Honor.
Thank you. Before you came out, Mr. Klein's mentioned something about, he thought it'd be shorter, but I've got a lot of questions for you on the Nelson hearing.
Yes, sir.
Mr. Lucy, we didn't go through this before, did we?
No, sir, there was a Ferretta hearing some time ago, and
Right.
talking to Dr. McDonald.
Good. Yes, sir. Okay, so on the Nelson hearing, you're requesting to discharge your attorney, correct?
Yes, sir.
What are the reasons for that?
Over the span, I'm going on nearly 8 months, and over the span, I've probably talked to him a grand total of 8 minutes. I'm still trying to get key discovery in preparation for trial. To my knowledge, no depositions haven't been done. There hasn't been any talk of trial strategy, no talk of resolution with the state on my behalf. And I just think that after 8 months, that's unreasonable.
Okay. Any other reasons why you believe Mr. Klein is rendering ineffective assistance?
Other than due process, no, sir.
Okay. Mr. Klein, you'll raise your right hand.
Yes, sir.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. 8 minutes into 8 months, no depots, no talk of trial.
Your Honor, the first time that I met with Mr. Losey was August 30th. That was our first meeting. And I met him again on October 12th. We had some discussions with Dr. McDonald. I met Mr. Losey again, I believe, sometime in the month of December. There's two reasons why there's been a delay. Number one, the delay was originally, we were never served the actual order appointing the expert. And so we didn't know it existed for a month. And Once we learned about it, we had Dr. McDonald evaluate him within weeks. And Mr. Losi actually caused the delay in that evaluation. I was at the jail when Dr. McDonald ended the evaluation after about 5 minutes. And I was standing talking to Mr. Nopes in the hallway, and they come out of the room, and neither one of them looked happy. And once Mr. Losi was back in the holding cell, I asked Dr. McDonald what it was. She indicated that he pretended he couldn't speak English, and that he then started talking about some kind of a extradition to Michigan, which that's the first I'd ever heard of Michigan.
And when was that?
That actually took place on Halloween. That's the reason why I know the date.
Thank you.
Mr. Losi was back before the court, and I don't remember the date, but I believe that the court essentially kind of said, you gotta be evaluated. He was evaluated by Dr. McDonald eventually. We did get that evaluation report back in, give me 1 second. So I believe on November 3rd, the court issued an order actually on November 3rd, the court ordered that Mr. Losi comply with the evaluation of Dr. McDonald. So we also had to have an actual court order that Mr. Losi comply with the evaluation. He did. He's filed a number of pro se motions, so I'm trying to have to go through those. Dr. McDonald eventually did find him competent to proceed. We got that report on January 3rd of 2023. And he and I met after that to talk about that. I can tell the court I personally handed Mr. Losi in court all of the paper discovery that I had on one of his court appearances. So he has all the paper discovery that I have. I can also tell the court that there are 20 civilian witnesses in this particular case, not even mentioning the law enforcement officers that are involved. And this court, I'm sure, is at least somewhat aware of the deposition backlog that we have encountered during the past 12 to 15 months, where Mr. Gomez can verify. He and I took depositions all day on this past Tuesday. We're taking depositions all day tomorrow. We're taking depositions all day next Tuesday and all day next Thursday. So I understand Mr. Losi's frustrated by the delay in taking depositions. He and I are in the same boat in that position. I agree. It normally should not take this long, but it has, because there's been some unfortunate personnel issues arising between the offices here. And it is what it is. We're moving as quickly as we can. Mr.
Pines, let me ask you that.
Sure.
What is your office's policy when an evaluation is sought? As far as you communicating with your client after a psychological evaluation is sought? Do you still communicate with your clients in the same frequency as you would if that wasn't pending?
I would have to say I'm not completely, couldn't tell you the office policy on that. The way I kind of react is, until the evaluation's done, there's nothing, other than just putting deposition names on a list and reviewing some discovery on my own. I don't typically go talk to the individual a lot, because until there's a determination of competency, I have too many other cases that's not an issue and that are moving forward. And so I know he's frustrated. He's also qualifies for PRR sentencing. State's current offer in this particular case is 30 years in prison. I don't know what else to tell him. I reviewed the Nelson hearing. The Nelson hearing actual request seems to indicate that he believes that 2 experts should have been appointed. He cited specifically to the case of Kaufman versus State, which I read, which is from 1983, which clearly has an older version of that 3.210 rule of criminal procedure. And that particular version does say the defendant shall be examined by no more than 3 nor fewer than 2 experts. That's not the current version of that rule. It just says no more than 3 as needed. It got rid of the less than 2. So we've had him evaluated. Dr. McDonald, after a delay caused by Mr. Losi, said, yes, we think he's competent. I didn't even get that until January 3rd of this year. So less than 60 days ago.
Understand. Mr. Losi, do you have any questions?
Yes, sir, I do. The order appointing the first expert for competency evaluation was signed by Your Honor on 8/31/22.
To my knowledge, at that time, the proceedings were stayed, and the prosecution may not advance at any material stage, including that of a plea. On 9/14, a plea was entered on my behalf. And on Halloween, as Mr. Klein said, the expert finally showed up to the evaluation. The reason why that evaluation was refused is the expert exceeded, the order was no good as far as my understanding of the law. The expert exceeded the First Judicial Circuit's due process rate pursuant to Administrative Order 2019-50, which is on the motion, ordering the expert. This access constitutes additional required motions and orders before any service was rendered, and there was not on record. So, due to violating the due process rate, I was trying to make that clear to the doctor, the court, and Mr. Klein's, that I believe additional orders, but nevertheless, that expert, the delay was not caused by me. She didn't show up to do the initial evaluation until 62 days after. And I believe the rule states that it was supposed to be done within 20 days, pursuant to Rule 3.210.
Mr. Losi, it's not typical for the court, for this court, to enter an order requiring a defendant to submit to a psychological evaluation. That was within your control. And so, based on that, also, I believe, well, I know from all the cases that I've got in this division, I don't like it, but the delay in depositions, scheduling those with the state is a lot longer than it was before COVID. Respectfully, your motion for new counsel for ineffective assistance of counsel, the court doesn't find that. So your motion is denied. Mr. Klein, will I see Mr. Losi back here on March 13th?
His case has already been continued to May. I did ask my assistant today, and I believe the depositions in this case should start in April. And as I said, I mean, there's 20 plus law enforcement. This thing, given the facts and the potential punishments that Mr. Losi's, I personally don't like doing a ton of depositions, especially unnecessary ones, but my willingness to do them goes up as the potential punishments go up. And so I will do them as fast as I possibly can, but I've got other clients facing similar lengthy prison sentences as well.
Mr. Losi, I'll see you no later than May 8th.
Yes, Your Honor, if I may, for the record, I have no confidence whatsoever in the proceedings with Mr. Klein as my counsel, and I don't want to proceed with him as my counsel. I just wanted to put that on the record.
Thank you, sir. Okay. What else do we have this afternoon?
The court is still waiting on Destiny Wakefield. She's individual was on Zoom on a plane.
Yes, sir. What happened with Palmer?
I did not see Mr. Palmer on for today, Your Honor, and actually just yesterday. You're talking about Robert Palmer?
Yes, sir.
Just yesterday, I actually asked my assistant to reschedule that for the first available hearing date in March. When I was getting ready for today, I was like, why isn't Mr. Palmer not on here?
And I hand wrote it into my docket for some reason.